This is Erica Merrill, and I'm the founder of Perfect Legal Video. And I am very excited to have with us today attorney Jim Sorenson. He is one of the partners over at Sorenson Van Leuven out of Tallahassee, Florida. And he is going to tell us about some very, very important updates in the law as it pertains to credit unions. And I mean, we're very excited to have you, and I know that this is all very recent. So thank you so much for joining us today, Jim.
Thank you for having me, Erica. I'm excited to be here, and we have a lot to talk about today. There's been a lot of activity of changes in the law. So we have a Supreme Court case to talk about, and we have a lot of action by the Consumer Financial Protection Bureau that we're going to be discussing today.
That's fantastic. And I was reading through some of the information, and it's going to be very vital for the credit unions to find out about this stuff. All these updates are going to really affect their future. So this is great. Speaking of these recent Supreme Court decisions of interest to credit unions, can you give us a little bit more information on this case?
Yes. So on April 1st, the Supreme Court issued an opinion in a case that had been watched by the credit union industry and really all creditors out there. This has been on our radar for some time. And in the case is Facebook versus, and I'm sure I'm going to mispronounce the last name here, but DeGuide, I assume is how you pronounce it. If not, I apologize. But this is a case that a lawsuit was brought against Facebook. It had to do with text messages under the Telephone Consumer Protection Act. And the issue that went up on appeal to the Supreme Court was involved the definition of an automatic telephone dialing system. So the TCPA, or the Telephone Consumer Protection Act, is a law that governs phone calls to or calls or texts to cell phones, mobile numbers, using a automatic telephone dialing system. And the question is, what qualifies as an ATDS, or an automatic telephone dialing system? And so this was the issue that came before the Supreme Court. What is the definition? And as you can imagine, there was disagreements about that. And so the court ended up siding with or adopting the position that the creditors wanted it to. And in a 9-0 ruling, the court adopted the creditor-friendly interpretation, holding that an ATDS must have the capacity to either to store a telephone number using a random or sequential number generator, or to produce a telephone number using a random sequential number generator. It's a rather technical ruling, but the key in this is it was the position that creditors wanted, and it was the position that the consumer groups were fighting against. And so that is the Facebook court decision that came out last week.
Wow, that is so interesting. I mean, it sounds like history in the making. Is it often that you see a 9-0 ruling?
No, it's not. You know, you think about the Supreme Court, and of course, we think about our country right now, where we seem divided on everything. We argue about everything, and the Supreme Court has become more political in recent years, and polarized in recent years, and a lot of decisions by the Supreme Court tends to be 5-4, 6-3 decisions. So it is rare in a case like this, where there's a lot at stake and disagreements from both sides. It's rare to see a 9-0 ruling, but all the justices agreed, and so I think there's some refreshing, at least in my opinion, it's refreshing to see that the court was unanimous. I realize they ruled in the way I wanted them to, but it still is refreshing to see the justices agree and issue this opinion.
Well, I'm glad that it went your way. It sounds like we're talking about sports here, but absolutely, we need to see decisions that are going to protect the businesses. And credit unions are a business, and their livelihood often depends on being able to collect their money that they lend out. And this is one of the ways that they do it. So while the court adopted the creditor-backed position, does this mean that all disputes about what qualifies as an automatic telephone dialing system is now resolved?
Unfortunately, no. The court did provide one answer, but there are still other parts of the definition, other words that are part of the definition that are still in dispute. And sometimes that's the frustrating process. People who aren't familiar with how appeals courts work or how the Supreme Court works, we think, oh, there's a decision by the Supreme Court and it resolves all disputes, all controversies. And unfortunately, it doesn't. They take the one issue that's before them. The lower court made a ruling. It was appealed by Facebook, and Facebook ended up convincing the Supreme Court to take this case, and the Supreme Court ended up reversing the lower court and adopting the Facebook creditor definition. But there are still other disputes out there about the TCPA and the language in it. So while this will eliminate one dispute, or at least clarify one dispute, there's still other issues that are left to be dealt with, either by the court itself, by the Supreme Court, or by Congress. Congress, of course, could modify the law, could amend the law to provide clarity, and so that is where we're ultimately going to be. Is there's either going to be another court ruling on this, or Congress maybe takes this law and adds some clarity to it.
Yeah, no, I can't wait to hear about some of the other updates that are coming down the pike on that. I know that automated dialers have just always been a hot topic of dispute for years, as long as they've been invented.
And there are restrictions, and on the number of calls. This really didn't have to do as much with the number of calls they receive. It has to do with, when does a telephone system qualify as an ATDS, and when does it not? And that has been a dispute that has been raging now for really the past 6-7 years. And the clarity the court provides here is good for business, because what's always hard as a lawyer when we say, well, it depends on what court you're in front of, how a court interprets it. Clients don't like to hear that. What do you mean it depends? They want a clear answer. Is this an ATDS or is this not? This court goes a long way towards answering that question. Again, it doesn't answer all questions, but it does provide some clarity. And for that, we're glad.
Well, absolutely. Let's move on to the CFPB, because they always have something interesting happening. So I understand that there's been a flurry of activity over at the Consumer Financial Protection Bureau, and would love to know a little bit more about what's going on over there with some of the decisions that they've recently made during COVID.
Yeah, the CFPB these past week and a half has been very busy, and it's interesting. The CFPB is, of course, a government agency. There is a new acting director in place. He was appointed after President Biden's inauguration. I believe, if I remember correctly, it was the day of his inauguration that afternoon. And the permanent director to lead that agency has still not been confirmed by Congress yet. I don't know the timing on that, but that nomination is pending before Congress, and most people believe it will go through. He is currently, the individual that's been chosen is currently a commissioner at the FCC, so he's already been approved by the Senate in the past, and would assume that when they get to him, they will approve him again. But the current acting director has the CFPB really moving forward with a lot of different agenda items. And this past week and a half, we saw 3 things out of the CFPB that is of interest to the credit union industry. So first of all, on April 1st, they issued a compliance bulletin really more of a warning. And this warning was directed to all the mortgage servicers out there. So mortgage servicers are those creditors and those other entities that maybe aren't technically the owner of the debt, but they service mortgage loans on behalf of the creditors. And this compliance bulletin was warning those mortgage servicers that they need to be prepared to comply with the law, and that failure to be prepared to comply with the law is unacceptable. On April 5th, the CFPB proposed a rule to amend the mortgage servicing rules. So again, focusing on mortgage loans, they've put out proposed amendments to the existing rules that would put additional requirements on creditors dealing with mortgage loans. And then on April 7th, the CFPB issued a proposed change to the debt collection rules that were promulgated last fall. And they're proposing a delay to the effective date of those rules. So all of this coming down in roughly a week's time seems to be really, as you said, a flurry of activity for a federal agency.
It sounds like there is a lot going on, and I'm personally surprised there's so many changes, but I know that, because of COVID and we're in a pandemic, which is a situation, we have not been in a very long time. Sometimes adjustments have to be made, and it's good to see that they are making adjustments as they see fit. So what can you share with us about the compliance bulletin that was issued on April 1st?
The CFPB is concerned about, obviously, the pandemic and the fallout from the pandemic. And, they mention in this compliance bulletin that there are nearly 3 million homeowners who are behind on their mortgage and could possibly face foreclosure in the foreseeable future. And so what this bulletin is doing is warning those who deal with mortgage loans that this possible wave of foreclosure could be coming later this year. And what's unique about this is they're issuing this preemptive warning. They're saying, look, mortgage servicers, look, creditors, you need to take all necessary steps now to be ready for this wave of foreclosures, for this wave of borrowers needing assistance. And you need to have in place sufficient staff to handle the surge or the expected surge of borrowers requesting assistance, whether that's workout assistance, repayment options, other loss mitigation concerns. Back during the Great Recession that happened 10 plus years ago, a lot of the mortgage servicers were just inundated with consumers needing help, and they weren't sufficiently staffed. And there was a lot of complaints and a lot of problems where borrowers were reaching out to their lenders and not able to get an answer, and not being able to get a response, and facing foreclosure. And that was something the CFPB, back when it first came into existence, addressed in the mortgage servicing rules it adopted. And these mortgage servicing rules place requirements on the lenders that they have to deal with the delinquent borrower, that during the foreclosure process, if the delinquent borrower wants to discuss their options, there are rules that have to be followed and timely action has to be taken. And so what the CFPB is doing in this bulletin is simply saying, look, the fact that you may get a bunch of calls and a bunch of requests does not excuse your non-compliance. It's easy to comply when you're just getting a handful of requests. It's much harder to comply with the law when you're getting thousands of requests. And so this is a warning. Thousands of requests, you still have to comply, and you better get staffed up, and you better be ready to deal with it. And that's really, it's simply that. It's a warning. And it is somewhat of a reverse of a position that CFPB took last year under President Trump. While the CFPB has always contended that the creditors have to comply with the law, a year ago there was a recognition that because of the pandemic, because of people out of the office, because of people working remotely, that as long as creditors were showing a good faith effort to comply, the court was, or excuse me, not the court, the Bureau was going to take into consideration the fact that we were in the middle of a pandemic and logistics may be hard. And so there may be some technical non-compliance which would be overlooked as long as the creditor was taking reasonable steps in a pandemic. Now the CFPB seems to be saying a year later, look, we've been living with the pandemic for a year. You can't use that as an excuse anymore. And you have to comply with the law. So that's really what this bulletin was all about, was a somewhat of a change in position, but also a warning that in the future, the CFPB was going to look differently if there was non-compliance.
That makes a lot of sense. And I got to be honest, there are definitely some companies that I personally deal with for my own services that, they just constantly blame the pandemic. And, like they're saying, it's been a year. Let's get our processes together so that people can be serviced the way that they expect to be serviced. A lot of people are just using it as an excuse now to stay with a very low staff and save money for themselves when, it's pretty serious when you can't get an answer on a house that you might lose and information that you need in order to save it. So I'm glad that they are making those changes.
And, for most of our clients, this isn't an issue. I mean, credit unions have traditionally been good about working with borrowers and being responsive. But obviously, this warning doesn't single anybody out. It's to the whole industry as a whole, whether it's Wells Fargo, one of the biggest mortgage servicers out there, Bank of America, one of the other big servicers out there, to the smallest bank or credit union. They're all being told, look, you got to comply with the law, and the pandemic is not an excuse.
Well, I know that your clients aren't having a problem. They have you to help them come up with processes through the pandemic so that they can stay, lean and mean and, out there helping their clients as best they can, even during a pandemic. I mean, you're used to this. You've helped them through disaster recovery situations with hurricanes, and they look to you to help them through these types of situations to keep them afloat and profitable.
Yeah, and we have, this last year has been a challenge at points. But now we're a year into this thing. You've got to have figured out all the loose ends have to have been tied now, and and hopefully we don't have to deal with the pandemic much longer. But who knows, right? Who knows? A year ago, I didn't think we'd have to deal with the pandemic much longer, and I was obviously wrong. I hope I'm right this time, but we'll see.
Hey, people are out there getting vaccinated, and it's millions and millions of people a day now. So it's exciting, and it's nice to be able to hug your family again. So I'm glad.
And I got my first shot. So 2 weeks, I'll get my second shot. So I'm on my way.
Oh, I'm getting my first shot on Saturday. So yeah, we're going to be all set for traveling and not have to worry as much.
That's exactly right.
So what about the proposed changes to the mortgage servicing rules?
Yeah, so the CFPB obviously has given this warning about this potential wave of foreclosures. And so what they've done now is they've proposed some changes to the mortgage servicing rules to deal with or limit the wave of foreclosures later this fall. And so the proposal really has three main parts to it. One, and probably the most important and the most far-reaching, is it will give a pause to allow borrowers more time to resolve their delinquencies by preventing foreclosures going through December 31st, 2021. All the federally backed mortgages, so VA mortgages, FHA mortgages, USDA backed mortgages, Fannie mortgages, Freddie mortgages, all those mortgages are currently under a moratorium for foreclosure. So in some of those cases, you have mortgages where people have been on a moratorium going back to March of 2020. And that moratorium lasts through June 30th of this year, 2021. So you will have people who arguably have not made a payment for 15 months or longer. And when that moratorium lifts, if there isn't a plan to resolve the 15-month delinquency, foreclosures would start happening. And so what the CFPB is doing is kind of putting this pause in place to allow borrowers and servicers to hopefully find a solution that avoids the foreclosure. Second, they're allowing for a streamlined loan modification. This is only for COVID modification. So it has to be a COVID related hardship. It can't be a hardship that's not COVID related. But these streamlined loan modifications hopefully will result in faster resolution. And then third is keeping the consumers informed of their options. And they're proposing to do this by changing some of the required communication that the creditors, mortgage servicers have to send out to borrowers when a loan is delinquent prior to foreclosure. So these are the main three components of the proposed amendments to the mortgage servicing rules.
Wow. I mean, that's really interesting. And what I'm wondering as I hear you discuss this, does the proposed rule apply to all creditors who hold mortgages?
The rule as proposed does not apply to all creditors. So under the mortgage servicing rules, there's a definition of small servicer, and small servicers are smaller credit unions, banks that do not have large mortgage portfolios. And it's a numbers game, it's a size limit. But small servicers as proposed would not be subject to these rule changes. But again, it's a proposal, and that could change. What's proposed now may not be the effectual rule that goes into place later this year. We're going to have to wait and see. But as the CFPB issued the proposal, it would not apply to small servicers in its current form.
I mean, that makes sense. When would you say all of these changes are going to happen for these proposed rules?
Yeah, it's hard to know 100% on the timing. Under the rulemaking process in the federal for federal agencies, when they release a proposed rule, they have to give a comment period. In this case, they've shortened the comment period because of the pandemic, but there's a comment period that runs through May 10th. So after May 10th, they can then issue and probably will the final amendments. Whether they will look exactly as they look today or whether there will be further changes, I don't know. Some of that's going to depend on the comments received by the CFPB. But one would expect that they're going to move rather quickly and try to get a final rule out in late May, early June at the latest, I would think, because again, the moratoriums that are in place right now run through June 30th. Now, the president, of course, could extend those moratoriums, but that seems to be the timing as best as I can guess.
So, what can you tell us about the delay of the effective date of the debt collection rules?
Yeah, so the rule as proposed would take effect on August 31st, and what's interesting is, as I mentioned, the current moratorium ends on June 30th. So you're going to have a period, basically July and August, where the new rule doesn't take effect and the moratorium expires. Now, what could be happening behind the scenes, and the CFPB doesn't indicate this, is the president is going to extend the moratorium 2 more months through August. That is one possibility. I don't know that, but reading between the lines. Otherwise, you're going to have a 2-month gap where there isn't a solution, and you're going to start to potentially see foreclosures pick up. We're just going to have to see what happens on that.
I mean, absolutely. And this was great because you've given us so many updates on all of the changes that we've talked about in the past. And I think that is so important for credit unions to understand, because sometimes you read something and you think, okay, we got it. and you don't always see when the changes happen. And that's why I'm glad we do these interviews, because you can really keep people up to date on what's happening right now. And all of these changes have happened within the last week. So this has been wonderful for you to bring this to everybody so quickly. Ken, now if anyone does have questions on any of the changes in the rules or any of the issues that we've discussed today, should they give you a call?
Yeah, they can reach out to our office. I do want to mention that we are going to be hosting a virtual roundtable on April 22nd. So this will be, we've done these in the past, over the past year. And so it's just about an hour set aside to go through some of these changes with the CFPB in much more detail, and discuss how this is going to directly impact the credit unions. There'll be a time for some questions and answers. So if anybody's interested in that, they can go to our firm website and register for that, or they can reach out to Whitney in my office, and she can register them for that event. There's no cost, but we do need them to register in advance, just that they're wanting to attend, so we can get them the Zoom information, and so they can join that virtual roundtable on April 22nd.
Well, that's wonderful. And I can't wait to watch that roundtable. I know that it's going to be really exciting with all the newest information. I want to thank you so much for coming on today, Jim. It really does mean the world to us, and we're lucky to have you.
Well, thank you, Erica. Happy to be on the show today, and glad to be able to talk about all these issues that credit unions are facing.
Thank you so much. We look forward to seeing you next time. And thank you everyone out there for watching. Have a wonderful day.